Good evening, everybody. Hello. Welcome to the University of Colorado Law School. For those of you who don't know me, my name is Jim Anaya. I'm the Dean of the Law School. It's my distinct pleasure to welcome you to the 45th Annual Austin W. Scott Jr. Lecture. I hope you all had a nice Thanksgiving and you managed to survive the snow with good cheer. The Scott Lecture was established in 1973 by former Dean Don Sears in memory of Professor Scott, who taught at the law school for 20 years. Professor Scott is known to have been an excellent teacher as well as a scholar. And so every year we select a member of the faculty who reflects this commitment to excellence to give the Scott Lecture. As you can see from the list of previous Scott Lectures in your program, being chosen to give the Scott Lecture is indeed a recognition of remarkable distinction. So it's with great enthusiasm that tonight we finally, at last, add to this distinguished list of Scott Lectures Professor Helen Norton. Helen Norton joined the Colorado Law faculty in 2007 after earlier serving as a visiting professor at the University of Maryland School of Law and as the E. George Rudolph Distinguished Visiting Chair at the University of Wyoming College of Law. Her scholarly and teaching interests include constitutional law, civil rights, and employment discrimination law. She has been honored with the Excellence in Teaching Award on multiple occasions and was appointed a University of Colorado Presidential Teaching Scholar in 2014. Added to her distinction as a law professor, she has been a public servant for a long time. In 2008, she served as a leader of President-elect Obama's transition team charged with reviewing the Equal Employment Opportunity Commission, and she is frequently invited to testify before Congress and federal agencies on civil rights and policy issues. Before becoming a law professor, Professor Norton served as Deputy Assistant Attorney General for Civil Rights at the U.S. Department of Justice, where she managed the Civil Rights Division's Employment Litigation, Educational Opportunities, and Coordination and Review sections. Additionally, she was Director of Legal and Public Policy at the National Partnership for Women and Families, where she practiced appellate litigation and engaged in administrative and legislative advocacy on a range of employment and civil rights matters. Professor Norton holds a JD from University of California, Berkeley Law School, where she was an associate editor of the California Law Review, and a BA from Stanford University, where she graduated with distinction. Professor Norton is a scholar with a prodigious body of work. She recently added to her impressive list of publications with her book, The Government Speech and the Constitution. In her talk tonight, which is drawn from the book, Professor Norton will discuss the uses and abuses of the government's expressive powers through the lens of constitutional law. Please join me in welcoming to the podium Professor Helen Norton.
Good evening. Thanks so much to you all for taking time out of your lives to spend an evening with us. Pulling together an event like this takes a great deal of hard work, and I want to start by thanking the folks who did all the hard and terrific work to make this possible. I want everybody to turn around and look at Yesenia Delgado right there in the back. Yesenia is our events manager who did a terrific job in making this happen, joined by Julia Roth, who's our communications director, and Melissa Schechter, our faculty events coordinator. So my plan tonight is to talk for about 40 or 45 minutes, if you can stand it, and then open it up for questions and discussion for about 15 or 20 minutes. And after that, the dean has generously offered to buy us all a beer in that room right next door. So I hope that you'll stick around and join us for that. Governments must speak in order to govern, and so governments have been speaking for as long as there have been governments. And the government is unique among speakers because of its coercive power as sovereign, because of its considerable resources, because of its privileged access to key information, and because of its wide variety of speaking roles as commander-in-chief, policymaker, healthcare provider, educator, employer, property owner, and more. So the government speech has unusual capacity both for value and for harm precisely because it comes from the government. Now, at its core, constitutional law is about the abuses and uses of the government's power, and this should include the abuses and uses of the government's expressive powers. We're used to thinking about the constitutional rules that apply to what the government does rather than to what the government says. We're used to thinking about speech as something that the Constitution protects rather than something that itself might violate the Constitution. So thinking about the constitutional rules that apply to the government's speech invite important and challenging questions about the nature of speech and about the nature of government. What value does the government speech offer us? What dangers does the government speech threaten? Does the Constitution protect us from those dangers? These are the sorts of questions that I'm interested in. Now, by way of background, note that when I talk about the government's speech, with respect to the government, I mean the collective speech of a government body, like an agency's report or a legislature's resolution. And I also mean the speech of an individual who's empowered to speak for that body, like the Secretary of Health and Human Services, or like a congressional committee chair. And I'm also including an individual who speaks when backed by the government's power, like a police officer when interrogating a suspect. I'm going to put aside for now the speech of an individual government official or an individual government legislator when she's speaking in her personal rather than in her governmental capacity, although I acknowledge that the line between those two roles is not always bright. And when I talk about the government's speech, of course I mean the spoken and written word, but I also mean monuments and other public displays that express the government's views about who and what deserves recognition. And I'm distinguishing the government's speech, what some call its soft power, from the government's lawmaking and its other regulatory actions that control private parties' actions through, for example, criminal or civil liability. Here too, I acknowledge that the distinction between the government's soft powers, its speech, and its hard lawmaking regulatory powers is not always easy to see. So here are a few examples of what I mean by the government's speech with its variety of content, speakers, audiences, motivations, and consequences. The Surgeon General's report on the dangers of tobacco. The Johnson and Nixon administration's lies about what the US was doing in Vietnam. The Forest Service's Smokey Bear and his message that only you can prevent wildfires. The District of Columbia's motto of protest, displayed on its license plates. Donald Trump's tweets as president. A 1950 Senate subcommittee report entitled The Employment of Homosexuals and Other Sex Perverts in Government. A wide variety of the government's religious displays, prayers, and other religious references. Federal, state, and local agency speech, everything from military recruiting to emergency warnings, flu warnings, the list goes on and on. Once you start to listen for the government speech, you'll start to hear it everywhere, sometimes in surprising places. And the more we recognize the volume and the variety of the government speech in our lives, the more thoughtfully, I hope, that we can think about its constitutional implications. So that's my first objective for this talk, to encourage you to look and listen for the government speech throughout your day. Now, many disciplines can help us think about the government speech. Philosophers and political scientists, for instance, can help us understand when the government speech is good or not as a matter of moral or democratic theory. and linguists and behavioral experts can help us understand how speech shapes its listeners' behavior for better and for worse. And I hope that anybody interested in the uses and abuses of the government's power will engage these questions. But as a constitutional scholar and teacher and lawyer, I view these problems through the lens of constitutional law. So my second objective for this talk is to describe some of the constitutional questions that the government speech triggers and to offer a framework to help us think about those questions. And more specifically, I suggest a framework that requires us to wrestle with what I'm going to call first stage and second stage government speech problems. And what I call first stage government speech problems force us to figure out when the government itself is speaking and when the government instead is actually regulating our speech. And this is important because the constitutional rules that apply to the government as a speaker are very different from the constitutional rules that apply to the government as a regulator of our speech. Now, if and when we decide that the government itself is speaking, then we turn to what I'm going to call second stage government speech problems, which consider whether and when the government speech violates specific constitutional rights. In other words, some constitutional limits still apply to the government speech, even though those limits differ from those that apply to the government's regulation. Even though the governments have been speaking for as long as there have been governments, only recently has the Supreme Court recognized government speech as an exercise of governmental power with constitutional implications of its own. And the government needs the power to speak in order to govern. Regardless of whether you love or you hate the government speech, its expression generates important conversations and informs our political and other choices. So the Supreme Court's government speech doctrine recognizes this reality, and by doctrine I mean the body of the court's judicial precedent in this area. And this precedent understands the government to have a defense, a shield, from free speech clause challenges brought by non-governmental parties who are trying to shut down or change what is really the government's own speech. So this doctrine explains why tobacco companies don't have a First Amendment right to force the Surgeon General to deliver their views on the benefits of cigarettes. And this doctrine explains why the administration's political critics don't have a First Amendment right to share the podium at the President's State of the Union address. What the First Amendment protects instead is those dissenting speakers' right to issue their own reports and to hold their own press conferences. So, for example, when President Trump tweets from the Twitter account that he uses to speak to the world about government business, he tweets as the government, and he's engaging in government speech. This means that his critics don't have a First Amendment right to stop him from tweeting or to change his tweets, just as they have no First Amendment right to snatch his microphone at the State of the Union address. But when Trump blocks those who disagree with him from the Twitter account that he uses to deliver government speech, he also does that as the government. And as a federal appellate court held last summer, the First Amendment forbids the president or any other governmental actor from excluding members of the public from a public forum simply because he doesn't like their views. And that case attracted a lot of attention, deservedly so, because it involved the president and his Twitter account. But the First Amendment rules, the First Amendment analysis don't change with the identity of the government speaker or with the expressive technology that he uses. Now, most of the time, the governmental source of a message is clear. Again, think of the Surgeon General's report on the dangers of tobacco. Surgeon General's name is on that report. We know it comes from the government. And the same is true of most of the government's expression. Its websites, its proclamations, speeches, websites, and more. The governmental source of those messages is clear. More difficult first-stage government speech problems involve various forms of interaction or collaboration between the government and private speakers that create interactions and collaborations that create doubt or controversy about who's really the speaker. So a good example of this is the long-standing controversy over specialty license plates, a controversy that was recently resolved by the Supreme Court when it held that specialty license plates are the government's own speech, subject to the government's own control, such that Texas, for example, could choose or choose not to produce a plate that featured a Confederate flag at the request of the group, the Sons of Confederate Veterans. I want to use the remainder of my time on what I'm calling second stage government speech problems. These problems focus on whether and when specific constitutional provisions, like the Establishment Clause, the Equal Protection Clause, the Due Process Clause, the Free Speech Clause, whether and when specific constitutional protections restrain the government speech. And I'm interested in these problems for a variety of reasons, including the fact that the Supreme Court has failed in any sustained or coherent way to grapple with the ways in which the government's speech itself, by itself, sometimes violates specific constitutional protections. In other words, the Supreme Court's government speech doctrine is incomplete. So here I'm proposing a framework for thinking about these problems, a framework for evaluating the government speech for constitutional purposes. And I suggest that we ask and answer a series of questions about the consequences of the government speech and the motivations underlying the government speech. So first, if we focus on certain harmful effects, we ask when the government speech changes its targets, choices, or opportunities to their disadvantage, and whether the Constitution forbids the government from causing those changes. In other words, this question asks whether and when the government speech interferes with its listeners' choices or opportunities in ways that would violate a specific constitutional right if the government caused those same changes through its traditional lawmaking or regulatory exercise of its hard law power. So think, for example, of the government's threats that silence dissenters as effectively as jailing them. Think about the government's lies that can pressure their targets into relinquishing their constitutional rights as effectively as denying those rights altogether. Or think of the government's religious speech in certain circumstances that coerces listeners' participation in prayer or other religious observance as effectively as fining or taxing folks who refuse to participate. Now, this approach requires us to wrestle sometimes with hard causal questions, difficult questions about the causal connection between the government speech on the one hand and harm to its targets, choices, and opportunities on the other. The quicker we are to see that causal connection, and some of us will be quicker than others to see that causal connection, the quicker we are to see that causal connection, the more we encourage the government to think twice about its expressive choices, the more we protect its targets from the harms of that speech. On the other hand, the quicker we are to see that causal connection, the more we constrain the government speech, the more we may cramp its speech, its expression, its communication in counterproductive ways. Because for the most part, the more the government speaks, the better for us, the more we learn about our government. Even the government speech that makes us crazy is constitutionally valuable. Another approach remains focused on the effects of the government speech, but it looks to different effects, different injuries. Here we ask whether the government speech has injured its target's dignity by treating them as outsiders to the political community, by failing to treat them with equal concern, equal respect because of who they are or because of what they believe. Think, for instance, of the government speech that communicates hostility towards its targets based on their religion or their non-religion or their race or their gender or their sexual orientation. This approach requires that we wrestle with difficult questions about when the government speech actually delivers that sort of message of hostility or disrespect. And it also requires us to think about difficult questions regarding whether a specific constitutional provision even protects us from those sorts of harms. A third approach turns from the potentially harmful effects of the government speech to the purposes for the government speech, the reasons why the government is speaking. What are the purposes motivating the government speech, and does the Constitution forbid the government from seeking to achieve those purposes? In other words, sometimes the government seeks to accomplish objectives that some of us, maybe many of us, find morally wrong or constitutionally illegitimate. This might be the case, for example, of the government speech intended to advance some religions at the expense of others, or the government speech intended to harm members of marginalized groups, or the government speech intended to interfere with constitutionally protected rights. This approach requires us to identify the government's reasons for speaking, and that is sometimes but not always easy to do, And it also requires us to determine whether a specific constitutional provision even denies the government the power to speak for certain purposes. So I'm offering these three sets of questions as three different ways to capture our intuitions about when and how the government's speech is constitutionally dangerous. And each draws from pockets of theory and doctrine. Each has its strengths and its weaknesses. And as we'll see, our preferences among these approaches are often driven by our theory of a specific constitutional provision. In other words, our understanding of the reasons we even have that constitutional provision. And because different constitutional rights often protect very different constitutional values, our preferences, even among the approaches, might change from provision to provision. Let me give you an example of what I'm talking about. I'm going to turn to the Establishment Clause, which provides that the government shall make no law respecting an establishment of religion. And I'm starting here for a variety of reasons. One of them is because the values underlying the Establishment Clause remain so deeply contested, so deeply controversial. In other words, we continue to debate, as we have for centuries, the answer to the question of why the Constitution prohibits the government from establishing religion. And I'm also going to start with the Establishment Clause because courts and commentators to date have most often considered what I'm calling second-stage government speech problems in this setting. And they did so long before the court ever developed a vocabulary, much less a doctrine involving government speech. So this is my synthesis, my take on how we should think about the Establishment Clause questions that are sometimes triggered by the government's religious speech. This is the state of Maryland's cross. It is a 40-foot cross. It stands on a median strip outside of Bladensburg, Maryland. And this cross was the subject of a case that made its way to the Supreme Court last year. I think we should think about this problem by going through my three sets of questions. If you think that the most important value, maybe the only value, underlying the Establishment Clause is protecting individual religious autonomy from the government's interference, then you'll be especially attracted to the first of the questions, which holds that the government's religious speech inflicts harmful and constitutionally forbidden consequences when it coerces onlookers' participation in prayer or other religious practice. Nobody thought that the Maryland's cross coerced onlookers' religious behavior. In other words, it doesn't pressure anybody to pray or genuflect or do anything. So there's no Establishment Clause violation if you take the non-coercion approach. Now, even if we do take the non-coercion approach, in other settings, some of us will be quicker to see the government speech as coercive. When they were on the court, for example, Justices Scalia and Kennedy both agreed that the only time the government's religious speech violates the Establishment Clause is when it coerces its onlookers. But they had very different views about when the government speech actually was coercive. Scalia's answer to this question was almost never. The government's religious speech only coerces onlookers when it threatens them with jail or fines or taxes. Justice Kennedy was quicker to see the government's coercion. So, for example, Justice Kennedy felt that social dynamics and peer pressure could coerce listeners, onlookers, into joining the government's prayer or other religious practice. And he saw this especially in the case of government-sponsored prayer in the public schools, for example, at graduation ceremonies and before football games. Now, if you instead think that the Establishment Clause is not just about religious autonomy, but that it's also about equality and inclusiveness, about protecting individual status as full members of the community, regardless of their religion or non-religion, then you might be attracted to this second question. This is another way of thinking about Justice O'Connor's endorsement analysis. And under her view, the government's religious speech violates the Establishment Clause when it endorses or denigrates a specific religion, or when it otherwise communicates that our status as citizens, as insiders or outsiders to the political community turns on our religion or our non-religion. Here, too, we can expect disagreements, even if we agree to look at the possible expressive harm of the government speech. So last spring, the majority and the dissent in the case before the Supreme Court disagreed about just this issue. The dissent argued that Maryland's cross communicated a governmental message that impermissibly endorsed Christianity over other faiths. The majority, on the other hand, argued that the message delivered by this cross changed over time, and that regardless of what it was understood to mean at the time it was erected as a World War I memorial, that over time it had been come to be understood not as a religious memorial, but instead as communicating respect for historical tradition, reverence for the war dead, that it acquired a more secular meaning over time. And finally, if you think that the Establishment Clause is about ensuring the government's even-handedness, its neutrality in all things religious, then you may be attracted to the third question, which finds that the government speech violates the Establishment Clause if it's motivated by an intent to advance some religions over others, or by an intent to advance religion over non-religion. For example, at one point, the Supreme Court held that Arkansas public schools' refusal to teach evolution violated the Establishment Clause because it was motivated by the state's desire to advance certain religious views about the origins of life. Now, the difficulties of these three sets of questions counsel that we proceed with care. We may justifiably worry that efforts to constrain the government speech through constitutional litigation will deter government speakers from engaging in important government speech, or will invite partisan rather than principled attacks from the government's critics. And the lawyers in the room may be wondering whether any of these claims are even justiciable. In other words, whether or not federal courts have the power to hear them. It turns out that the answer to that question is sometimes, and if that's of interest, I can talk more about that in the Q&A. But even though constitutional litigation is an imperfect and incomplete tool for curbing abuses of the government's expressive powers, it still has value. The ugliest of the government's expressive choices are often those that are least susceptible to political, to non-legal remedies, because the government often speaks in hurtful ways precisely because that speech is politically successful, precisely because that speech appeals to its preferred constituencies. And this can be the case, for example, when the government targets vulnerable communities or unpopular dissenters. So the judiciary can offer an independent check on the government's abuse of its expressive powers. In the remainder of my time, let's take a closer look at a couple other second stage problems. Free speech clause. The free speech clause permits, and the government speech doctrine permits the government to resist other speech through the force of its ideas, but not through its legal or physical force. When the government uses its lawmaking or its other regulatory power to punish dissent, for example, when it jails dissenters or taxes them or fines them, it violates the free speech clause. And under some circumstances, I think, the government can achieve the same forbidden effects through its speech, as is the case, for example, of its speech that threatens or encourages retaliation against disfavored speakers. So first I'll do what I think is an easy case, then I'll turn to a hard case. This is an example of what I think is an easy case. These are excerpts from several judicial opinions that are describing how during the 1950s and the 1960s, a Mississippi state agency circulated damaging information and falsehoods to the employers, friends, families, and neighbors of citizens who were speaking out against segregation. And the state agency made these claims, made these misrepresentations with the express purpose of silencing desegregation and other civil rights work. All of this was done in secret, so the government's destructive speech wasn't exposed until decades later. But the agency's speech violates the free speech clause under any of the frameworks that I've suggested. First, the free speech clause prohibits the government's falsehoods like these when they cause a third party to fire or otherwise retaliate against the government's critics. In other words, the government's speech violates the free speech clause when it causes the sorts of harmful effects that we would understand the Constitution to prohibit if those same effects were caused by the government's hard law, its lawmaking, its regulatory action. For sure, we will sometimes disagree about when the government's speech actually causes those forbidden effects, but the causal connection in the Mississippi case was very direct, very clear. Next, if we think that the free speech clause forbids the government from inflicting expressive or dignitary harm against disfavored speakers, we may or may not think that, but if we do, the agency's speech violates the free speech clause if it humiliates or disparages its targets because of their protected expression. And this too is a likely result. given the nature of Mississippi's lies about its targets' criminal behavior, sexual behavior, drug use, and more. And finally, if we turn instead to the government's reasons, its purposes for speaking, the government's speech violates the free speech clause if it's intended to punish or silence protected expression. Also the case here. But for sure, we can imagine more difficult second stage government problems. Think, for example, of President Trump and his speech calling for the firing of National Football League players who chose to kneel during the national anthem to protest ongoing racial injustice in America. And note that those protests absolutely positively protected by the Constitution from the government's hard law, from the government's regulation, from its punishment by jailing or fining or taxing them. So these are some of the things that Trump tweeted or said about the players in speeches. Now, the NFL's response to the players was mixed, at times supportive, at times antagonistic to them. Some of the protesting players struggled for years to find a team willing to offer them contracts. And in particular, Colin Kaepernick, the quarterback who started the protests, has not played in the NFL since 2016, even though many NFL teams are clearly hurting for quality quarterbacks. Now, if we focus on the speech silencing harm to the players' choices and opportunities, Trump's speech violated the free speech clause if it threatened to punish its targets for their speech, or if it coerced or significantly encouraged the NFL's retaliation. Was Trump just criticizing the protesters? Or was he threatening their jobs? If Trump's speech coerced or encouraged the NFL to retaliate against them by denying them employment, then it violated the free speech clause. But here, the causal connection between Trump's speech and Kaepernick's longstanding unemployment is not clear. If we instead understand the free speech clause to bar the government from inflicting expressive or dignitary harm on disfavored speakers, and again, we might or might not, but if we do, Trump's speech violates the free speech clause if it communicates that the protesting players are unworthy of respect as participants in public discourse. Does calling Colin Kaepernick a son of a bitch deliver that message? Or repeatedly urging that protesting players be fired? And finally, if we turn from the possible effects of Trump's speech to the purposes for it, if we understand the free speech clause as denying the government the power to speak for certain purposes, to speak for the purposes of punishing or silencing protected speech, then Trump's speech violates the free speech clause if he intended to punish or silence the protests. And maybe he did. On the other hand, Trump might argue that he sought only to criticize and not to punish or silence. He might even argue that he wanted the protests to continue because they inspired his political base. In other words, it's not always easy to figure out why the government speaks for a certain reason. Now, again, I don't pretend that the framework I've suggested here will make hard second stage problems easy, and I do expect that reasonable people will disagree about the application of this framework to certain specific problems. But my point is that the exercise of asking and trying to answer these questions illuminates what makes hard problems hard and what makes easy problems easy, and that in itself is an important step towards principled problem solving, principled thinking about these problems. What's important for my discussion here is that each of these three approaches demonstrates a different way to think about whether and when the government's speech by itself violates the Constitution. Finally, the Equal Protection Clause. Like all hateful words, the government's hateful speech hurts. But the government's hateful speech sometimes hurts more and differently and more dangerously precisely because it comes from the government. So here I'd like us to think about the second stage question of whether and when the government speech violates the Equal Protection Clause. Once again, we're going to turn to what I hope by now is a very familiar set of questions about the consequences of and the motivations underlying the government speech. So first, let's think about the effects, the harmful consequences of the government speech by exploring how the government speech sometimes changes its targets' choices and opportunities in discriminatory ways. Here are a few examples from long before the court had a vocabulary, much less a doctrine, for government speech. In the 1960s, for example, the Supreme Court held that city official speech, New Orleans city official speech, that commanded private restaurants to continue to engage in segregation, that speech was sufficiently threatening, sufficiently coercive to violate the Equal Protection Clause. And in another case, also from Louisiana, also from the 1960s, the court held that Louisiana's law that required the government to print ballots that identified all political candidates by race, that law violated the Equal Protection Clause because it enabled and encouraged voters to discriminate on the basis of race. In other words, the government speech on those ballots disclosed candidates' race at a critical point in voters' decision-making, the moment before they cast the ballot, at a time and in a place where African Americans' voting rights were under siege. Relatedly, the government speech can also deter its targets from pursuing certain opportunities as effectively as an outright command, as effectively as hard law. Consider a government employer that says only whites need apply. So in other words, we can understand the Equal Protection Clause to forbid the government speech that commands, threatens, and coerces third parties to discriminate, or that substantially encourages or enables third parties to discriminate. These are all effects that we would understand the Equal Protection Clause to prohibit if they were caused by the government's lawmaking, by its hard law action. So the same should be true if we get the same effects from the government speech. And again, we can and will sometimes disagree about when the government speech without more achieves those constitutionally forbidden effects. So next, let's think about whether and when the government speech inflicts expressive or dignitary harm on its targets, and whether the Equal Protection Clause even forbids the government from causing that harm. If we understand the Equal Protection Clause to require that the government treat all of us with equal respect, equal concern, regardless of our protected class status, then the government speech alone may violate that clause when it communicates exclusion or inferiority or supremacy based on protected class status. Some have made this argument with respect to the government's incorporation of the Confederate logo into state flags, or the government's choice to display Confederate flags or Confederate monuments on state capitol grounds or elsewhere. And these challengers argue that the government's display of the Confederate flag communicates a governmental message of racial supremacy. They argue this in part because of the Confederacy's express origins in white supremacy. Alexander Stephens, the Vice President of the Confederate States of America, explained at the time that the Confederacy was the first nation in the history of the world expressly founded with a goal to achieve racial supremacy. And they further argue that the government's display of the Confederate flag communicates a governmental message of racial supremacy in light of the fact that a number of southern states began incorporating the flag into their flags or into their state capitol displays in the 1950s and 60s in opposition to the Supreme Court's decision in and federal enforcement of Brown versus Board of Education. Now, to be sure, whether we should understand the Equal Protection Clause or the Establishment Clause or any other constitutional provision to protect us from the government's expressive harms, from its dignitary harms, is deeply controversial. Critics worry that assessing the government's expressive meaning inevitably brings about inconsistent, subjective, unpredictable results. Some, for example, argue that whatever the meaning of the Confederate flag at the time of its adoption, that today it should instead be understood as a celebration of Southern heritage rather than hate, that its meaning itself is contested. So finally, let's turn from the consequences of the government speech to its purposes. The Supreme Court has held that the Equal Protection Clause denies the government the power to act when motivated by animus. In other words, when motivated by its hostility to or its bare dislike towards certain individuals or groups, like the government's irrational prejudice towards persons with disabilities, or the government's desire to harm members of the gay and lesbian community. Now, this invites the question whether we should also understand the Equal Protection Clause to limit the government's power to speak when its speech is motivated by animus, by hostility. And those who think the answer to this question is yes may do so for instrumental reasons. If the government intends to cause harm, it will be more likely to cause harm. Those who answer yes to this question may do so based on moral intuitions, on the notion that it's just wrong for the government to try to hurt people, regardless of whether it does so through words or deeds? And those who think the answer to this question should be yes, may do so based on a theory of the government's constitutional power. In other words, under this theory, the Constitution does not empower the government to try to harm us, or otherwise to speak or act for non-public regarding purposes. Now, for sure, animus doctrine itself triggers substantial controversy, even when it's used to strike down the government's actions, much less its speech. And critics, again, argue that the effort to determine the government's motivations are hopelessly subjective and indeterminate. And they also worry that branding government actors as motivated by hostility or animus demeans and denigrates those decision makers themselves and contributes to polarization and conflict. So let's work through one last example, and then I'll close. I've posted here Alabama law. Alabama and Texas law currently require public schools' sex education curriculum to include, quote, an emphasis in a factual manner and from a public health perspective that homosexuality is not a lifestyle acceptable to the general public, and that homosexual conduct is a criminal offense under the laws of our state. Does this government speech violate the Equal Protection Clause? If we focus on discriminatory harm to target's choices and opportunities, we ask whether a challenger can show that the government's speech commanded, coerced, or encouraged third parties to discriminate against gay or lesbian students, whether the government's speech deterred those students from seeking certain opportunities, whether the government's speech created a hostile educational environment. And it's not hard to imagine that the government speech of this type could encourage bullying or other discrimination by other students, especially given its misleading claim that same-sex sexual behavior is a criminal offense. Yes, the laws criminalizing same-sex sexual behavior remain on the books in Alabama and Texas and several other states, but no, those laws are not enforceable since the Supreme Court has held them to be unconstitutional. It's also not hard to imagine that the government speech of this type could create a hostile educational environment, as lesbian and gay students face an obstacle to thriving in their educational environment that others don't face when the government is telling them and their classmates that theirs is not a life acceptable to the general public. Now, at the same time, we can expect and should expect disputes about the causal connection between the government's speech and those discriminatory consequences. We can anticipate disputes about whether the government speech, for example, actually rises to the level of a hostile educational environment. If we turn to the next question, if we think instead about expressive harm, then we'd ask whether reasonable onlookers would understand the government here to be communicating a message of inferiority or second-class status, and whether the Equal Protection Clause even forbids the government to communicate those messages. And as is so often the case, this is going to turn on who our reasonable observer is. Is it a lesbian or gay teenager? Or the child of lesbian or gay parents? Is it someone whose religion teaches that same-sex sexual behavior is morally wrong? Is it somebody who hasn't thought about it much? And your preference here will probably turn on whether or not you take an anti-subordination or an anti-classification view to the Equal Protection Clause. Finally, if we focus instead on the purposes underlying the government speech, here we ask whether or not the government speech was motivated by animus, by hostility towards gay and lesbian students. The state will likely argue that its choice is motivated not by hostility, but by its moral and pedagogical views about healthy sexual behavior. But the court has indicated in several cases that that sort of moral disapproval in this context can be a type of animus. So if we step back, we can see the cleavages, we can see the points of contention. The government speech violates the Equal Protection Clause when it causes certain discriminatory effects, but some of us will be quicker than others to see that causal connection. And whether the Equal Protection Clause forbids the government from sending denigrating messages that inflict expressive harm, whether the Equal Protection Clause forbids the government's speech inspired by its animus, turns in part on our assessment of courts' institutional competence to determine expressive meaning and the government's motivation. These are legitimate concerns, and they suggest that often we should try to see if we can find non-constitutional responses, in other words, responses other than resort to constitutional litigation to the government speech that we find dangerous, statutory, political, structural, expressive strategies for influencing the government speech, strategies that are available to legislatures, to lawyers, to whistleblowers, to press, to the people themselves. But under some circumstances, we can understand the government speech to violate specific constitutional protections when it inflicts certain injuries or when it seeks to accomplish certain illegitimate purposes. So in other words, the answer to the question, when does the government speech violate the Constitution, is not never, but instead sometimes. We've got about 15 minutes before the dean starts serving beer, so I welcome your questions and your comments.
Can you hear me? Okay. We've obviously got a rather infamous or famous president right now who uses a lot of what could be interpreted as harmful speech, but they're not directed toward political classes necessarily. It's anybody who he is out of favor with at the moment. Does this analysis apply to that, or is he just because he's president, nobody is really taking him to task for his speech? From a legal perspective.
Yeah, thank you for the question. So this analysis should apply to any governmental actor, with the possible exception of Congress when it engages in speech that's covered by the speech and debate clause. There's a specific constitutional provision that protects members of Congress from any sort of liability for their speech when they're engaged in legislative functions. But this analysis should apply to any other government actor as a legal matter. And I think the Second Circuit Court of Appeals decision over the summer was a promising step in that direction, right? When it held that President Trump engaged in government speech, permissible government speech, when he tweets, when he uses his Twitter account to speak on government's business, he can do that. And if you don't like it, there's nothing, you don't have a First Amendment claim against him. But then when he chooses to speak on a platform that permits the public to interact with him, and he doesn't have to choose that sort of platform, but if he chooses to speak on a platform that permits the public to interact with him, he's created a type of public forum. And the First Amendment forbids him from picking and choosing who can participate, who can speak on that forum based on their viewpoint. So a long way of saying the same analysis should apply regardless of the government speaker and regardless of the type of expressive technology that they're using.
Okay, the first stupid question, probably the only one. So, when Trump said, sorry, we're back. It could have been a 400-pound guy sitting in his underwear at home or something who wrote that. What if that some other 400, not other, but any person who looks like they weigh 400 pounds, who's male, applied for a job the very next day after he said that, tweeted it, or whatever. And they did not hire him. Could you address that?
I know what you're doing right now. If you are anything like my students, and I see many students, both current and former right now, that all of you are generating hypotheticals right now. And I appreciate that. I want you to do that. The one thing I want you to take away from this is a framework for thinking about the hypotheticals and for solving them yourself. So if you think about what interested you, right? Lots of people are nodding. They like that hypothetical. If you think about what interests you about that hypothetical, right? What's interesting, what's hard, what's challenging, or what annoys you about it, right? You think about it. But what I want you to take away is I hope now that you actually have the tools for thinking about that yourself. And if you've come up with a sufficiently hard hypothetical, we can disagree about the result, which is fine with me, at least for tonight. At least for tonight, what I want us to try to do is to agree that we're going to have a framework for thinking about it and talking about it.
So this is incredibly impressive, and I particularly am impressed by your ability to move through all these different silos of constitutional law that are not always in conversation with each other. My question has to do with your framework and some of the bridging between those silos. So I'm looking at this largely through a First Amendment perspective, and it strikes me that your framework for thinking about second stage problems will actually take on a certain cast if it's done through a lens of thinking about speech through a First Amendment doctrine perspective. So to try to make that clearer, there's First Amendment doctrine that deals with the link between speech and harm, like Brandenburg's incitement standard. And there's First Amendment doctrine that deals with when speech creates a dignitary or expressive harm that is not regulable because it's not considered to be enough of a harm. And it strikes me that a court that's looking at this and seeing the word speech is going to look at your framework and come to certain conclusions about how to handle 1 and 2 in particular, if they sort of have their free speech hats on. So have you thought through the fact that, or I guess the possibility that a court that's primed to be thinking through its own lens of its own speech doctrine might actually have predetermined answers to 1 and 2 that differ from your own intuitions on those?
Sure, thank you. It's a terrific question. And I'm not proposing. I'm proposing this as a way to think about it. I'm not proposing that every court will buy into each of them. And I'm also proposing that your answer might be different depending on the constitutional provision at issue. So, for example, you might be quicker to think, well, the Establishment Clause, maybe the Equal Protection Clause is in part about expressive harm, dignitary harm. That's certainly the endorsement approach. There's a body of doctrine there. But you might think the Free Speech Clause is not about that. The Free Speech Clause is not about protecting us from the government disparaging us because it doesn't like our speech. You don't have to buy into it. If we have intuitions, as some of you do, if you hear a government speaker, it could be the president, it could be any other government speaker, and the speech enrages you, right, or irritates you, or annoys you, I want us to think about why that is. And I think sometimes the answers are it's morally wrong. And I think sometimes the answers are it's instrumentally dangerous because it's politically divisive. That often may be true. I'm going to leave that to other experts. And I think occasionally the answer is because it's a constitutional problem. And I'm trying to think through when and why it might be a constitutional problem. So finally getting to your question. The government, I think the answer to that is to remain focused on the fact that the government is both like and unlike any other speaker. So you are worried, understandably, that courts will focus on its speech. The government is like any other speaker. We need to treat this like any other speech. And if we don't think that a private speaker's speech that inflicts dignitary harm inflicts harm of the sort that permits the government to regulate, we shouldn't be troubled if the government inflicts that same harm, if that's your statement. And maybe that's the right answer. But then I would ask you to think about the fact that government is unlike any other speaker because the government does not have First Amendment rights. Right? The Constitution protects us from the government and not vice versa. And the government, as a speaker, as a regulator, as an actor, because it is the government, has the power to inflict harms that are different from any other actor, including any other speaker. And once you acknowledge that, I think it's fair to say that at least sometimes that might mean we treat the government speech differently than we treat private party speech.
Hi. I love how this merged different elements of the First Amendment from speech to establishment. I want to ask you about the enumerated powers. And it struck me that certain things like speech about Colin Kaepernick, could it be challenged in your view as just beyond any enumerated power of the president or Congress? And it's done by the president, but pursuant to any powers the president has that are enforcing or implementing enactments of Congress. That's, of course, broad, the power to execute and to enforce the laws. But let's assume that the president's speech about Colin Kaepernick was issued from the White House podium as government business, or that the Twitter feed is deemed to be government speech. It's hard to come up with any purpose of the government that he's executing. And in a sense, would you see your argument as much supporting a structural powers of government argument that, as with many challenges to government action, it can be challenged as A, beyond any enumerated power, and B, a violation of some individual right, and it can be challenged independently as both? And in a sense, I feel like some of your First Amendment analysis alluded to that when you talked about bare desire to harm is the only purpose for certain speech. You were almost already touching on the idea that this is not speech the government is authorized to engage in for any legitimate purpose. So I hadn't thought about this before, so I'd just be curious about your thoughts about whether there could be a structural government challenge here. There's a question of standing, but Kaepernick could, or similarly a speech that just trashes the New York Times and encourages people not to subscribe anymore. Could that generate standing for a structural challenge?
Yeah, that's another terrific question. So if I understand you correctly, you're wondering, with respect to the president's speech, is there an argument that it exceeds his Article 2 inherent authority, right? That we should, however we understand the scope of his Article 2 inherent authority, it doesn't include this. I'm open to that. I mean, for sure, I focused on individual constitutional protections because they are such, or they can be specific constraints on the government's power. But I'm open to I'm open to that possibility. And I suppose if I were bringing that claim, I would bring it in the alternative, right? I would argue the Constitution does not empower the president to hurt us, right, through our speech or to lie to us, etc. Even if you have a broad understanding of the president's Article 2 power, then it's a separate question. Even if he has the Article 2 power to do that, he still might be violating a specific constitutional protection.
First of all, thank you so much for speaking to us today. One particular issue I found particularly interesting is relating free exercise and its conflict with the Establishment Clause. And I know we were talking about a hypothetical earlier that you kind of wanted to avoid that, so I'm sorry for asking one.
You can ask it if you answer it.
I mean, I'm thinking about in schools, say there's a teacher who has, like a high school, a particular teacher has a conflict or feels comfortable speaking to the class as long as they have a cross up by the whiteboard, like a particularly large cross sitting by the whiteboard, but that's what they feel comfortable speaking with, having it right there. I don't know whether it would have a particular discouragement towards the students or coerce them in any sort of manner. So I want to see what you would think using your framework towards a teacher who does something like that, and whether you think it's a constitutional act.
So are you currently in law school?
No, I'm just a freshman in undergrad.
Oh, excellent. Okay. That doesn't mean you get off the hook. Right?
Yikes.
Right. So this is what first-year law students they do. They sit back and think, that's very interesting. What about this? It's like, all right, one of my jobs is to give you, not to give you the answers, but to give you the tools for thinking about the answers. So what do you think? What made you ask this question? What troubled you or annoyed you or concerned you about it?
Well, I started thinking about the different levels. Like, first, what if there was like a cross and the teacher put it on all the tests? Like, it was at the top right. They were required to see it. They were required to think about it. I feel like there's a certain degree of, in order to complete the test, they have to look at that cross every single time they take one of the
They
tests.
were required to? The teacher said that?
If they decided not to take the test, they get a 0. So that cross is right there by the name. They're going to see it. I think there's a certain degree of coerciveness to that, requiring them to see something like that to some extent. Like, yes, they could hypothetically say you don't have to look at it, but I mean, when it's right there by your name, there's a certain degree of having to requiring you to see it. And so I think with it up by the board would be some sort of coercive nature, but to a very light extent that makes me question whether it exists.
Good. Well done. Well done. All right. So what I tell my students, among other things, is when they ask questions like this, especially when it's getting close to finals, and it is close to finals, and I appreciate the fact that many of you are here when you actually should be studying for finals. So thank you for coming. Right. But I asked them to write their own law school exams, right? I asked them to think about, how can I make this question hard? So I appreciate what you did, right? You created it was a hypothetical, right? Or have you lived this?
I have not lived that, just a hypothetical I've been thinking
right?
about.
Right, you created it because you started to think, what would I find coercive, right? What would I find coercive in the educational environment? And you started to construct some facts, and you can make it more coercive, right? You can make it an easier question. You could make it less coercive. You could make it a harder question. But the thing I want you to take away from is you want to think about, under what circumstances do I think that government speech is coercive? And you're basically saying sometimes, and I agree with that, sometimes.
Thank you.
I have the mic, so I'll go next. Thank you, Professor Norton, for this eloquent glimpse into your mind, something that we've often wondered about. Which I can say as a friend. So here's another hypothetical in the name of free speech. A government official tweets or otherwise communicates speech that could be categorized as hate speech, inciting one group of people to pick up arms against another group of people. Under the case of international law, this is prohibited because this is what happened in 1994 in Rwanda, leading to a genocide. Of course, it was radio, not tweet. So where in the framework do we see a capacity to constrain that kind of government speech?
Yeah. So thank you. It's a super question. It's actually not unrelated to Margot's in some. If we go back to traditional First Amendment law, which focuses on when the government can or can't regulate our speech, longstanding problem deals with when the government can regulate speech that seems to advocate violence or other illegal activity. And the rule that has emerged is that it is protected by the First Amendment unless and until it rises to the level of incitement, meaning the speech is directed to and likely to imminently cause violence or other illegal activity. If that's the nature of the speech, then it's unprotected by the First Amendment and the government can punish it at will. Okay, you're saying, what if the government does that? Okay, the First Amendment doesn't apply. The government doesn't have First Amendment rights. The First Amendment protects us from the government and not the government from us. But it causes harm. So I didn't talk about the due process clause here, but I would argue that government speech that actually incites violence. Now, of course, we're going to fight about that causal connection, right? When does the government speech actually incite violence? But if we agree, if we adopt your hypothetical that the government speech actually incites violence, I would say it's a violation of due process, meaning the government has deprived its targets of life, liberty, or property, but life without due process of law. Thank you all. Yeah.